MPs are accused of stalling the traditional courts bill to curry favour with chiefs ahead of the elections next year. 5 provinces have rejected the bill as unconstitutional, but civil society organisations say MPs should have sent it back to the Justice Department to be rewritten. We chat now to Thuto Thipe, a researcher at the Centre for Law and Society. Thuto, thank you so much for joining us on Morning News Today this morning. What is the issue with the traditional courts bill? Why is it so contentious?
Well, one of the starting premises for the Traditional Courts Bill is that it adopts the boundaries that are set up in the 2003 Traditional Leadership and Governance Framework Act. And these boundaries are the exact same boundaries of those of the former homelands. So within these boundaries of the former homelands, the Traditional Courts Bill sets up a completely separate system of governance and legislation. So what the Traditional Courts Bill says is that anybody who lives within the boundaries of the former homelands cannot use a magistrate's court, has to use a traditional court. You has to use a traditional court that is led by a senior traditional leader. And if a person does not appear before the court once called by the senior traditional leader, they are in contempt of court, and any rulings by the traditional courts have the same standing as a magistrate's court.
So where does this bill fit in with our constitution and in context of a constitutional democracy that we have?
This is a very important question because there are gross constitutional irregularities in the Traditional Courts Bill. The first being that it sets up the former homelands as a separate area apart from the rest of the country. And then within the traditional courts, people may not have legal representation. There is no specific legislation that applies within the boundaries of the traditional courts that protects people, especially marginalized groups such as women, children, LGBTI people, that would apply in magistrates' courts. And people within these boundaries cannot appeal many of the rulings by traditional leaders.
So
and
let's bring it home
an important aspect here. Sorry, can I just say that an important aspect of this Traditional Courts Bill is that it does not allow for separation of powers. So it allows senior traditional leaders to interpret the content of customary law, to then be the people adjudicating the courts, and then also be the ones enforcing the law. So the protections that we have in other parts of the country of separation of powers are made null and void by the Traditional Courts Bill.
Let's bring it home a little bit, Thuto, and explain what it means for the layman, for the people who might fall within the jurisdiction of the Traditional Courts Bill. What would it mean for them in their daily lives, or the issues that they might be trying to battle in courts?
I think an important point to start is that this bill does not represent custom as it is practiced by millions of people in the country. What this bill represents is apartheid and colonial distortions of custom, first with the boundaries of the former homelands, and with making senior traditional leaders the key focal point of customary law. So for people who live under customary law, this is a gross violation of customary law itself. The Traditional Courts Bill is using old premises, colonial understandings of customary law, and saying that this is what applies. And what's happening on the ground is that people use very different dispute resolution mechanisms and governance mechanisms. And the Traditional Courts Bill doesn't recognize this diversity. The Traditional Courts Bill standardizes what traditional courts are and says that other existing mechanisms and organizations are not recognized. So this would have enormous impacts for people for the roughly 16 million people who live within the boundaries of the former homelands. And this bill would make it very difficult for them to access the rights that they are entitled to as citizens of this country. The rights to a fair trial, the rights to, can I give you an example of some of the cases that we're working with? So there are cases in the Northwest and in Limpopo where enormous amounts of platinum have been discovered, where people are actual owners of land. Their ancestors bought land, and that land was stripped away from them and put under the ownership of traditional leaders under apartheid, and other people who live on communally owned land that was and were not allowed to, not recognized as owners because of apartheid laws, who are now not able to benefit from the mining that is happening on their land because of laws that do not recognize their ownership and that entrench power in traditional leaders
Thuto, very,
and
very
not on the
quickly
people
for us,
who live on land.
can government change this?
Government can change it. The bill is still in the NCOP. It's been, we're still waiting for outcome, so it's not too late. Government can change this.
Thank you very much. That was Thuto Thipe, a researcher at the Centre for Law and Society.
News that moves. eNCA.com.